Well, good afternoon, everybody, and welcome to another one of our SILA sessions in our Precognition to Proof series. This is our third session, and we have a new speaker today, Scott Clare. Scott is an advocate at the Scottish Bar, who called in 2022. He specialises in commercial, private and public law litigation, and is also a tutor at the University of Edinburgh, and so is well placed to deliver this session on effectively drafting an initial writ. My thanks go to Frazier Wright and Associates for sponsoring our Zoom platform, which makes these sessions possible, so thank you to them. And I just remind everyone of the usual kind of housekeeping, that is to keep mics and cameras off. And if all questions could go in the chat box below, I'm sure Scott wouldn't mind answering some questions at the end. So over to you, Scott. Thanks very much.
Thanks very much, Giorgio. Can I just check that you can hear me all right and everyone else can hear me?
We can indeed, yes.
Excellent. Thank you, everyone. Managed to just about overcome some technical difficulties there and sharing my screen. Thank you very much for all coming along today to this virtual seminar on drafting the initial writ as part of SILA's Precognition to Proof series. As Giorgio indicated, I'm an advocate at the Scottish Bar. I called at the end of June last year, so I'm a relative newbie. Prior to that, I cut my teeth in the Sheriff Courts mainly, so I have some experience in drafting initial writs. So I thought it would be useful to start with some words really on the purpose of written pleadings generally, given with the initial writ, we are at the start of the journey of written pleadings. And really to have in mind what the purpose of written pleadings in our adversarial system is. Well, in the case of ERDC Construction Limited against HM Love & Co in 1997, Lord Prosser stated as follows: whatever machinery is used for the resolution of a dispute, there is likely to be some place for both written and oral material. A requirement that each party should formulate its position in writing at the outset has fundamental advantages, not only as a means of giving fair notice to the other side and helping to focus and cut down the issues in dispute, but also and fundamentally as an encouragement to each party to analyse the substance of the case before trying to give it expression in writing. In my opinion, if a high quality of written formulation can be achieved at the outset, much expensive and time-consuming oral procedure can often be avoided. I would not therefore wish to say anything which might be interpreted as denying the importance of written formulation or encouraging recourse to oral evidence or submissions without such a written foundation. That said, I am quite satisfied that pleadings of the type currently used in ordinary court procedure are frequently, and indeed normally, ill-suited to their true function, failing to put essentials in sharp focus and often putting in sharp focus inessential matters of detail, which then become the subject of pointless procedural scrutiny. And we will unpack some of what Lord Prosser said there in this presentation. Well, fundamentals, what is the initial writ? As I'm sure a great many of you, or perhaps all of you, will know, the initial writ is a formal court document. But it is more than that. It is the first court document in the life cycle of a case. It should, if drafted properly, represent a written articulation of the basis for your client's claim, both in fact and in law. But more fundamentally, from my point of view, it is the first impression that you give to others of your case. And first impressions, as many of us know, can be tough and unforgiving. It's sometimes said that you never get the second chance at a first impression. So the question really to have in your mind when you're drafting an initial writ is, what do you want the first impression of your case to be? Now, that holds true whether it is the court or your opponent that is considering the first impression, the basis of your case. And I would suggest that if you wish to retain the ear of the court and the respect of your opponent, what you should really be trying to convey is that you understand properly the factual and legal basis for your claim, that you properly understand what it is you are seeking from the court and why in law you are entitled to that order. Well, we've spoke generally, I've quoted there a dictum of Lord Prosser on the function of written pleadings in our system, but what is the particular function of the initial writ? In many ways, we have to consider really the combined effect of the initial writ and the defences, the equivalent court documents prepared by the defender. But taken together, they should do a number of things. Fundamentally, they should set out a summary of each of the parties' case. And by doing that, it should define the factual and legal issues that are in the case. It should be clear to the court, for example, to see what facts are in dispute and what are admitted or what requires to be proven. They should provide notice to the court on substantive issues and procedural issues. Substantive is fair enough. It should set out, as I've said, that's really the factual and legal issues in the case, what the case is about, and why each party says, from the point of view of a pursuer, it is entitled to the order it seeks. Obviously, from the point of view of a defender, it would be why the pursuer is not entitled to the order it seeks. In terms of procedural issues, the initial writ has a number of functions in terms of procedural matters. If, for example, a party wishes to make a call on the other party to the action, there requires to be a basis for that in their pleadings. If a party wishes to proceed with a specification of documents to recover certain documents, then there requires to be a basis in the pleadings to do that. It will generally be in the form of a call placed upon the other party to produce something or to admit something which is not then done, and that would provide a basis for recovery. But the pleadings will also be looked at in example, for example, where res judicata is put forward as a defence. So where there is, and I appreciate this session is not concerned with defences, but it is a defence to say that the subject matter of the action has already been adjudicated upon. The court have already dealt with this case and made a decision about it. Now, in order for the court in those circumstances to properly decide whether that is a well-founded defence or not, it has to go back and look at what was litigated in the prior litigation. So in that sense, the written pleadings and the initial writ particularly are of crucial importance in setting out what the case is about, what was litigated, and what was decided. The writ should also provide notice to your opponent of what the issues in the case are. That's essentially what we call specification, and we'll come on to consider that. But I've put in there, they should also provide notice to yourself of what it is that you have to prove. And in that sense, an initial writ is a helpful aid memoir of what it is that you are actually required to prove. Who, for example, you need to come and give evidence to prove certain averments. It should also set out an effective agenda for the action, and that comes back to really dividing matters of substance into those which are not in dispute or which remain in dispute and will require to be proved. And finally, as I've said there, it sets out the scope for the evidence in the case. Now, you may have heard of objections on the basis of colloquially called no record. Another way of putting this, the phrase that's often used, if you don't plead it, you can't lead it. The initial writ sets out the parameters really within which you can go to proof. If you have not pled a specific line of your case and you start to ask a witness questions going down that direction, you will likely be met with an objection of no record or no basis in the pleadings for that evidence. So you need to really be thinking carefully about what it is you put in your pleadings, what you need to put in to be successful. When should you start thinking about preparing the initial writ? Well, I would suggest that most good litigators will start the process early. And really, as soon as a client comes to see you, they've given you a precognition, perhaps you've taken a precognition from them, and you have a grasp on what the nub of the case is, then it's no bad idea, really, to think about how you commit that to writing and how you would ultimately articulate that before the court. We come back to this issue of what is the basis for what you're seeking in fact, and what is the basis in law. At the very latest, really, you need to be thinking about it when alternative options to resolve your client's problem are no longer in prospect. What do you need to start preparing the writ? Well, you will almost always require a precognition from your client. I think you have already covered that in this series at the last session. So I don't propose to say any more about that, but you will need to have something from your client that sets out the basis of the claim. You may, in certain cases, require precognitions from others. That's fairly common. You ought to have any documentary evidence, if that is required, to support your claim to hand. Styles, quite commonly, you may want to have recourse to a style. Green's litigation styles and Bennett's style writs for use in the Sheriff Court are very useful resources. A slight word of caution in relation to that is that styles are just styles, and no style you get will exactly match the facts and circumstances of your case, so just bear that in mind. You may well also have internal styles, office styles floating about that someone else in the office can give you. And finally there, a textbook. There may be occasions where it's either an area of law that you're not familiar with, or you just want to cross-check, as I've said, in the exercise of being diligent, that you have properly understood the basis in fact and in law for your case. What is it that you need to aver and prove in order to be successful in, for example, an action for breach of contract? Well, you would need to set up that there was a contract between the parties. You would need to set up what the terms of that are, or insofar as they are relevant, that there was a breach by the defender, that you have sustained perhaps some loss as a result of that breach, how you've quantified that, and that you've called upon them to put right that loss, and the action is therefore necessary. What's the correct form of an initial writ? Well, happily, the rules of the Sheriff Court prescribe that. The relevant rule is Ordinary Clause Rule 3.1.1. Typically, the initial writ will be in a form G1, which is a reasonably straightforward style. There are, however, two notable exceptions. The first being that relating to commercial actions, which proceed under, I think it's Chapter 40 of the Ordinary Clause Rules. A commercial writ is in form G1A, which is slightly different. Notably, it has the words commercial action on the face of the writ. There are also personal injury actions which proceed under Chapter 36 of the Ordinary Clause Rules. They don't proceed in a form G1, they proceed in a form PI1 with certain notable changes in terms of how the condescendence is set out. It's actually called a statement of facts rather than a condescendence when you're dealing with a personal injury action, and notably no pleas in law either, which we will come on to. Both forms of procedure, commercial actions and personal injury actions, are designed that there is an abbreviated form of pleadings. So you would not necessarily have to plead and aver as much detail as you otherwise would in an ordinary action in a form G1. But beyond that, just given the confines of this presentation, I'm not going to go into commercial actions and personal injury actions, but do have a look at those. Looking then at the structure of the form G1, the standard style initial writ, as I say there, the basic rules are very basic indeed. and will require a bit of innovation from you. Really, the basic rules are that you must state which court you are raising the action in, and that will be the court that the writ is sent to ultimately. That would be the court and the sheriffdom in which that court sits. You must identify the names of the parties, that is your client, the pursuer, and also the defender. There may be multiple defenders, and you must provide an address for them, typically their home address, or if it's a business person, it will be a business address. And that is what we call the instance. Thirdly, you must state the specific decree, order, warrant that you are seeking. In other words, the order you're seeking the court to give you, and that's known as the crave. You are craving the court to do something. Fourthly, you must state that the court has jurisdiction to deal with the case. If you don't do that, then it is par judicis for the court to note that it does not have jurisdiction. In other words, that does not have to be brought to the attention of the court by the other side. The court, of its own volition, if it is not satisfied it has jurisdiction, can and should decline to hear the case. So you must state the basis on which the court has jurisdiction. Fifthly, you then require to insert a condescendence, which is essentially the bulk of your writ, and we'll come on to discuss that in some detail. Sixthly, you must insert pleas in law. Those are distinct legal propositions that set out the legal basis for your case. And finally, it requires to be signed by the solicitor. A writ that is not signed is a fundamental nullity. So breaking those down then, dealing firstly with the heading and the instance, and we'll probably add to that the description of the writ as well. The heading is reasonably straightforward. You are stating the sheriff court itself and the sheriffdom in which it sits. That goes at the top of the document. You're then required to describe the document. So in this case, underneath that, you'll be noting it as the initial writ in the case. There follows the instance, as I've said, setting out the names and addresses of the parties. And it's worth noting at this point that the pursuer is the so-called master of the instance. In other words, it is not, strictly speaking, open to the court or the defender, certainly not open to the defender, to seek to amend the instance. That is a matter for the pursuer. So the pursuer really has to be satisfied that they are convening and suing the correct party or parties, and that they have the correct spelling of their name, for example, the correct address. If there are any special capacities, we'll come on to those. They should be set out. In terms of those special capacities, you may have an individual person who is at risk, for example. If you have a pursuer in a harassment case and they don't wish the defender to know where it is that they reside, which would ordinarily be what you would put as their address in the instance, you may wish to design them care of Police Scotland or care of the solicitor, i.e. you. Companies and limited liability partnerships will have registered numbers. They should go in there. Generally speaking, companies and limited liability partnerships should be designed with their name, their registered number, bearing in mind that names of companies can and do change, whereas the company number does not, and also their registered office, or sometimes place of business. Partnerships, that is old style partnerships under the 1890 Act. You have to be careful, those of you who do clinical negligence work, quite often GP practices are still old-fashioned partnerships, and just to take care in how you design those. Generally that will be the partnership, the name of the practice, and the individual partners as individuals and as partners thereof. And you also need to be careful if the partners have changed over time, because it may have been a different set of partners at the time the negligence took place as to when you actually sue. So things like that to watch out for as well. One common special capacity is those of executors or trustees. An executor does not sue generally as an individual person. They will generally sue, or a trustee, they will generally sue in their capacity as an executor of a deceased person or as trustee of a trust. So that should be narrated. Joe Bloggs residing at such and such an address as executor of the late so-and-so who died, wherever. And finally, attorneys. This is another common capacity that people will often sue, not as an individual, but in their capacity as an attorney of someone under a power of attorney. Set out an example there of the heading and the instance. Quite typical in the Sheriff Dunlothian and Borders at Edinburgh. That's your heading. Initial writ, that is your description. In the cause, and we've got there the instance, that is the name and address to be inserted for the pursuer and defender. You may, as I've said, have multiple parties. You may have multiple pursuers. You may have multiple defenders. They should then be set out as first pursuer, second pursuer, first defender, second defender. Occasionally, less commonly, you may have a third party convened, and again, they should be designed there as a third party rather than as pursuer or defender. Moving on then to the crave. The crave sets out what orders fundamentally you are asking the court to make, be that a decree, a warrant, or an order, other order. It should, generally speaking, identify the order sought with precision. Now, that is particularly important when you are seeking something like an interdict. The courts get very exercised if an interdict is not precisely set out in the pleadings. And that is for the reason that a defender in breach of an interdict, that is treated effectively as a contempt of court and is a very serious matter. So it has to be absolutely clear what it is a defender is not permitted to do. Similarly, where you're seeking an order ad factum praestandum, that is an order effectively asking someone to do something, that should also be set out with some precision. The standard form of words there, that I'm sure will be familiar to most people, the pursuer craves the court. I think the bulk of claims are seeking a crave for payment. So it will be the pursuer craves the courts to order the defender to make payment to the pursuer of the sum of however much. I've put there cumulative craves, fairly typical. That essentially just means that the pursuer is seeking more than one order from the court. The way to do that really is the pursuer craves the court, colon, and set them out numerically in a logical fashion. If, for example, you are seeking interdict and damages, or a specific implement and damages, or something else, those would be cumulative craves. You're asking for 1 and 2. Alternative craves, you will sometimes have in an action where you seek specific implement. For example, you're asking the court to order a contract breaker to comply with the terms of the contract. That would be an order for a specific implement, craving that order. But if failing that, you would seek damages. So those would be alternative craves. That's not a cumulative crave where you're seeking 1 and 2. That's one where you're seeking 1 or 2. Another typical context in which that arises is actions for account reckoning and payment, something of a niche form of court procedure. Actions of account reckoning and payment are essentially actions where the defender has some obligation to make payment to the pursuer, or at least to the defender has some obligation to give an accounting to the pursuer. For example, the pursuer may be the beneficiary of an estate and they're not satisfied that they've received what they're due. So they sue the executor in an action of account reckoning and payment. And you ask the executor in the first place to give an accounting of what is due to the pursuer. You will often have a crave like that in an action like that accompanied by an alternative crave, which is failing that accounting being given, to order the defender to make payment of a certain sum as an alternative, if that isn't done. Are you seeking any interim orders? Typically, if you are seeking an interdict, for example, you will often seek an interim interdict while the action is depending rather. If that is the case, then you should have a specific crave for that interim order. Are you seeking diligence on the dependents? Well, more accurately, what you would be seeking is a warrant for diligence on the dependents, for example, to arrest funds in a bank account, to serve an earnings arrestment, to inhibit a defender so that they can't sell or otherwise dispose of heritable property. If you need a warrant from the courts to do that, then that should be sought as a separate crave. Interest, typically a crave for interest is tacked on to the end of the principal crave, which will be for payment of a sum of money, usually at the judicial rate, 8% per annum, although it is competent to seek a contractual rate if that has been agreed, or some other rate if there's a basis for that. In commercial cases, commercial debt cases, for example, there is a statutory form of interest that can be claimed under the Late Payment of Commercial Debts Interest Act 1998, so that's one to watch out for. As I say, not typically a standalone crave, it's just tacked on to the crave for payment. And finally, expenses. Always put in a crave for your expenses. Again, the courts can get fairly exercised if you've overlooked that and then ask the court to award you expenses. So there's an example of a crave, simple crave for payment. Pursuer craves the court to grant decree for payment by the defender to the pursuer of the sum. Now it's stated there, this is the convention for reasons unknown. The sum that you're seeking is always stated in words followed by the numerical in brackets. Sterling, perhaps fairly obvious. However, it is competent to seek expenses in a foreign currency, as it is to seek a principal sum in a foreign currency. So really that's to make that clear. With interest thereon, as I've said, that's typically tacked onto the end at the 8% per year. That's the judicial rate set by the court. Default rate, as it were, unless there's another rate that you say should apply from the date of citation. In other words, from the date the defender is served with the proceedings until payment. And that should be number 2, to find the defender liable to the pursuer in the expenses of the claim. So that's a fairly standard crave in most cases. Turning then to the condescendence, and I have to say, in my experience, this tends to be the part of the writ that people can struggle with. Condescendence really is a set of numbered paragraphs. Now, one technical point here, because I once made the error of referring to condescendence 3 and was swiftly told by a sheriff that there is only one condescendence. So just beware of that. There is one single condescendence, but there are a number of articles of condescendence. Those are the numbered paragraphs. And really, there is little prescribed in the Form G1 and the rules of court as to what goes in the condescendence, other than the first article should design the parties and state that the court has jurisdiction to hear the case. And as I've said, beyond that, it's really over to you. There are many ways of setting out the condescendence, but I would suggest the best way to approach it is to have in mind that you are telling the story. And at all times, as I've said, you're setting out the factual and legal basis as to why your client is entitled to the orders that they seek in the crave. I've given an example there in a fairly straightforward action for payment. As I say, there is no right or wrong way of doing this, but you may find this helpful. In Article 1, you would set out the designation of the parties, that the court has jurisdiction. Article 2, you may wish to set out the circumstances in which the contract that you're suing under was entered into. Really, that's just the factual background, the relationship between the parties and so on. Thirdly, you would set out that the invoices were rendered and have not been paid. And fourthly, as is common in all actions, you must at the end of your condescendence state that the action is necessary. If you don't do that, then you face being met with a plea of prematurity from the defender. In other words, you've taken this to court too soon, and that can have consequences in terms of expenses. Even if you are successful, the court may refuse expenses because essentially you didn't give the defender an opportunity to resolve this before going to court. Second example there, actions for damages for breach of contract, slightly different to an action for payment. Again, Article 1, you would expect to see the parties designed in the jurisdiction. Article 2, again, the circumstances in which the contract was entered into, tell the factual background. Thirdly, I would suggest then noting the specific item or the terms of the contract that you're relying on. In other words, that you are going to say have been breached. Fourthly, that the set out the facts which amounts to, you say, to a breach of that term or those terms. Fifthly, in an action for damages, you should always set out, whether that's contractual or a delictual case, that you have sustained a loss and that is a loss which sounds in damages. So in other words, you're entitled to compensation because of the loss that you have sustained. And again, as I've said there, finally, you must always set out that the action is necessary. And third example given there is a delictual action, as I've said, with the caveat that if it is particularly a personal injuries action, then you're looking at a form PI1 rather than a G1. So there will be slight nuances in how that is to be set out. But if you're looking at another form of delictual action, for example, a nuisance claim, Article 1, you would expect to see the party's jurisdiction. Article 2, rather than the circumstances of entering into the contract or the voluntary obligation, you would set out the circumstances of the delict that's occurred and that you say gives rise to some form of liability. Thirdly, you would want to set out the duties you say that were owed by the defender to the pursuer, which you say they've been breached. Fourthly, set out the loss, the injury and the damage. And finally, as always, that the action is necessary. So some fundamental rules about the condescendence. And you would be amazed how often these are not followed. Firstly, the absolute fundamental rule is that you should be pleading facts and not evidence. So it's said to be fundamental to our system of written pleadings that all a party should put in its pleadings, and particularly in the condescendence of an initial writ, are the facts which are necessary to enable that party to prove its case. You are not pleading the evidence by which you intend to prove those facts. Now, let me take an example of a contractual claim. It is a fact that the parties met on such an occasion and that they entered into a contract. Now, evidence would be that Party A said to Party B this, and Party B said he agreed, and therefore that made there a contract. That is evidence, that is not a fact. So you should be confining yourself to the facts alone and not the evidence by which you intend to prove those facts. So that's a fundamental rule. We should not plead evidence. Secondly, you want the condescendence to have a logical, and I would suggest a chronological order. So don't be darting about all over the place in terms of the chronology. Set it out as the factual background, the circumstances giving rise to the breach, why you say there is a loss that you've sustained, and finally the action is necessary. Keep it logical and keep it clear for the court. Relevant averments. Well, what do we mean by that? It's perhaps one of these things that is tends to be explained in the negative, what an irrelevant averment is. For an averment to be relevant, it must relate to the action that is before the court. If it is not a matter that the party requires to aver and prove in order to be successful, then on the face of it, it is irrelevant. Now, a plea to the relevancy is very typical. You will find it in almost every set of defences, often combined with a plea to the specification of the initial writ, and we'll discuss that next. But relevancy really is about what do you require to prove and what is surplus to that? Now, the classic formulation comes from a case called Jameson from 1952. If anyone is interested, I can give the citation for that, often wheeled out at debates. And the formulation in Jameson is that a party's action will only be, let me put this another way. I shouldn't have started down this route. A party's averments must be relevant in order to achieve the ends that it seeks. Let me come back to relevancy. That did not go well. In terms of specific averments, you must provide enough information to give fair notice to the defender. That is another criticism that is often wheeled out at debate, is that the defender does not have sufficient information to prepare its case. In terms of relevancy, I'm going to give an example. If you have an action for nuisance that your neighbour has used his property in such a way as to create a nuisance to you, and you're entitled to damages under a delict for that, then it is irrelevant if you put in your pleadings that you challenged your neighbour about that and he came to your door and gave you a torrent of abuse. That is not something that you require to aver and prove in order to be successful in your case. And the court will likely order that those averments are stricken from the initial writ. So when you're thinking of relevancy, it must be entirely what you need to prove and nothing beyond that. Specification, as I've said, providing sufficient notice to the defender of the case that you intend to lead so that they have a fair opportunity to make preparations and defend that claim themselves. Scandalous averments, something that comes up from time to time. An averment is scandalous if it makes comment on the immoral character of a party, particularly third parties to the litigation. An advocate with a small a, so that is all of you, should not be making averments as to moral character of third parties, particularly unless it is relevant to the pleading, so we're back to relevancy, and unless there is particularly compelling evidence to do that. There is a related rule when it comes to fraud, that an advocate should not plead fraud unless there is compelling evidence to do so. Don't plead law. This is another common fundamental one, and that really relates to the fact that the condescendents should be concerned with the facts that enable you to prove your case. We shouldn't be pleading law there. There is a notable exception in personal injury cases, typically where you are pleading a statutory case. The convention is typically to plead that the defender, sometimes an employer, was under various statutory obligations, so you're pleading the law there, and that they were breached. There is a divergence of views, I think it would be fair to say, on how correct that is, but it does happen. Generally speaking, as I say, we should not be pleading law. Short sentences, keep it clear, keep it crisp, keep it short. And duty of responsible pleading. This really is fundamental to our system of written pleadings. There are a number of aspects to this. Chiefly, we should only be putting in our pleading matters for which we have evidence that we can prove those pleadings by. There are, to take for example, a case of professional negligence. It's well established that a party should not make averments as to professional negligence unless it has expert evidence that supports such a claim. And obviously, it goes without saying, never mislead the court. Never put anything before the court that you know to be incorrect or in any way misleading. So there must be a basis for what we put in our pleadings, whether that is in the form of, for example, recognition or documentary evidence that you have, what we discussed at the beginning. Plain English. Again, this is something to which there is perhaps a divergence of views. Those lawyers of a certain vintage, perhaps, you may find are more keen or traditional thought, are more keen to retain Latin. I think there is a place for Latin. If you are going to use it, however, know what it means and know how to spell it. And I would suggest, as a general rule, you should only really use Latin if it is a convenient shortcut to what is otherwise a longer term in English. For example, quod ultra denied is quite acceptable, as opposed to saying insofar as everything else is concerned, denied. But there are some terms where it's just as easy to use the English. Nobody gets bamboozled by it, and it just is clearer. I tend to use, for example, in the cause rather than in causa, because it's just as short. But that would be my advice. And the trend is very much towards using plain English where possible. And I've given an example there of something that is horrendously florid. It is believed and averred further that separatum esto, the aforesaid obligations, which are held to be repeated here in brevitatis causa, were owed by the defender, as hereinbefore condescended upon, which is denied. The defender duly complied with said obligations as condescended upon by the defenders in answer 4, which are adopted and repeated herein mutatis mutandis, insofar as consistent herewith. What does that even mean? So best to avoid complex formulations and use plain English at all times. I've given an example there of a fairly straightforward condescendence in an action for payment. This would be, so in the first article, stating there the parties are designed in the instance. That's perfectly competent and valid. You don't need to state long form, the pursuer is so-and-so who resides at, the defender is so-and-so who resides at. You can simply refer back to the instance. Really, everything that follows there relates to the ground of jurisdiction. In this case, domicile of the defender, which is perhaps the most common form of ground of jurisdiction, rather. So setting that out there, the basis upon which the pursuer is entitled to raise this action in that court at that time. And thereafter, as I've said, it's really a matter for you how you set out the basis in fact and in law for your claim. Stated there, this is a case about work being done at someone's home. Pursuer is a bathroom fitter. In the second article, I've really narrated the circumstances in which that pursuer has carried out work for which they're entitled to be paid. In the third article of condescendence, I've stated out the circumstances in which that invoice was rendered and not paid, and fourthly, stating that the action is necessary. And that really relates back to the end of the previous article, where it stated the pursuer has failed to make payment despite having been called upon to do so. So you should always be narrating that you have given the defender the opportunity to put it right. Pleas in law. Your pleas in law are essentially discrete legal propositions which underpin the basis of your claim. That is a summary of the basis of your claim in law. What you want to be aiming for with your plea in law is that an outsider, perhaps your opponent, perhaps the court, can flick right to the back of your initial writ, bypassing the condescendence, and find out in a short, succinct nugget what your case is about. What is the legal basis that you say you're entitled to the orders set in your crave? So it is your case in a nutshell. And your pleas in law, as I've said, should relate back to your crave, and ultimately they are what you are asking the court to sustain. They should always be supported by relevant and specific averments. So they should have an underpinning, essentially, in the condescendence. They shouldn't just be thrown in there with no basis. I'm thinking principally of a defender's plea, something like no jurisdiction. If jurisdiction has not been denied in the condescendence, then there is no basis for a plea in law that there is no jurisdiction. They shouldn't be abstract propositions. It really should be that you are entitled to something by virtue of what has happened. That's a plea in law. And a single sentence. They shouldn't be more than one sentence. I've given an example there, which may be fairly apt for the condescendence example that I gave. The pursuer, having supplied goods and services to the defender as contracted for, is entitled to payment therefore. Therefore is a term that, an old-fashioned term that doesn't seem to have been shaken off, but essentially it means for it. So pursuer is entitled to payment for the work that they've carried out. That's what that plea in law is saying. Simple, short sentence, that's it. And second plea in law, that the sum sued for is the remaining balance of the contract price. Decree, again, therefore, for it, should be granted as craved, so as you're asking the court to do. So have that in mind with your plea in law. Can you flick to the end of the writ and see exactly what it is that the case is about in a nutshell, in a nugget? Signature by the agent, fairly fundamental, but again, I'm led to believe this happens quite often, and the writs are bounced. Having crafted your magnum opus, your perfect initial writ, don't forget to sign it. As you are instructed to do it as a solicitor, you'll be signing it in your capacity as agent for the pursuer. So that should be set out in a signing block together with your designation, who you are, that you're a solicitor, and your business address. Again, a fairly simple thing, but back to first impressions. What first impression do you want to give? Are you someone who has meticulously checked this, or are you someone who has, perhaps just fired it in? And worth bearing in mind too that an initial writ which is unsigned is a fundamental nullity. So it's void and of no effect. I've put there, I'm conscious that we're creeping up to 10 to 2 and there may be some questions. I have put there some further reading on the matter of written pleadings more generally. MacPhail is an extremely comprehensive treatment, as those of you who do a fair bit of sheriff court work will know. The Bible of all things, sheriff court, refer you to chapter 9 on written pleadings. Also good are Hennessy's 2 books, Civil Procedure and Practice, now I believe in its 5th edition. I'm now wondering about that, there may be a slightly newer version, chapter 3, again on written pleadings. And Practical Advocacy in the Sheriff Court, focused more on, as you would expect, practical advocacy than procedure, which the other book is more concerned with. Chapter 3 on written pleadings is also a good place to start. In terms of styles, Green's litigation styles are invaluable. All sorts of weird and wonderful actions that don't crop up every day, you will find styles for in there. And Stevenson, new edition, style writs for the Sheriff Court, I believe that just came out a few months ago. Again, very up to date, taking into account the abbreviated forms of pleading in commercial and personal injury actions, for example, a very good resource. But with the caveat, as I should say, with all styles, as I've said, they are styles and are not to be copied slavishly. They will always need to be adapted to the particular facts and circumstances of your own case. So really, that was everything that I intended to go over today. I think we've got a bit of time for questions, Giorgio.
Scott, that was excellent. Thank you very much. It's much appreciated. Yes, so if anyone's got any questions, if you just put them in the chat box below. I have a couple, if that's okay, just to get us going. I'd like to know your views on headings. I've heard lots of different views about putting headings in writs and summons, and yeah, particularly I suppose for more complex and lengthy writs. What's your view on putting that in for the condescendents? Oh, sorry, Scott, you're on mute.
Sorry, thanks, Giorgio. You're asking about breaking up the condescendents into headings. I think that is a perfectly valid way of proceeding. It tends to be a style that I've come across most commonly in the commercial courts. I know people quite like to set it out just in a way so you have jurisdiction, sort of backgrounds to the contract, breach of contract, loss arising therefrom, necessity of the action, and sort of do it that way. But I think perfectly valid. Some people will not like it done that way. Again, some people will find it quite helpful. I think by and large, again, sticking with the commercial angle, the commercial sheriffs seem to quite like that, just as a way of setting it out. One thing I didn't touch upon was breaking down to headings, but not breaking them down into multiple articles of condescendence. I think as a general rule, try and aim for about 5 or 6. I have heard it said, perhaps slightly cheekily, in the Sheriff Court that multiple articles of condescendence can suggest party litigant. So try and keep it in sort of slightly lengthier articles of condescendence rather than too many.
Great, thanks. And continuing with the commercial action point, last week we heard lots about how the LBA ties in with the pre-action protocol in the commercial court. Would you plead in a commercial writ that you have complied, that you have issued that pre-action correspondence, and if you've complied with the practice note, and that, say, for example, you haven't heard from the defender, would you put that in the space where you're essentially saying this action is necessary?
Yes, I was just going to say, I think naturally that would fit into that part of the pleadings, that you have complied with the protocol, and that again that's almost your equivalent of saying, the defender's been called upon to put this right, and they've failed to do so. There follows the action necessary. So I think that's perfectly valid.
Thank you. I'm just checking. There's a couple in the chat box.
The other thing to say, just on that, Georgia, while I remember, actually with commercial actions, certainly in the Court of Session, and if I'm recalling correctly, in the Sheriff Court, there may actually be a form that you have to fill in accompanying the writ, and just satisfying the court that you have actually complied with these sort of matters. So that may be before the court in another form. If that's the case, may not actually require to go into the writ.
Yep, perfect. Okay. I don't think we've got any further questions. Has anybody got anything else that they want to add? No, perfect. Well, that's 5 to 2, so that's perfect timing. Well, all it leaves me to say is thank you very much. It's very, very much appreciated, especially to give it your time, and those slides were excellent. Next week, we have defences. Catherine Muir is going to deliver the session. So all it leaves me to say is thank you once again, and enjoy the rest of your day. Cheers.